Welcome to another edition of Talk to the Experts on 770 CHQR. I'm your host, Randy Sharman, and with me today is Cindy Morin and Dr. Wesley Thiessen, who are both with the Resolve Legal Group. The website, if you want to check it out, is resolvelegalgroup.com, who offer a number of different legal services. We're going to talk about family law during Talk to the Experts today. So hello to the both of you.
Hi, Randy.
Hi, Randy.
Nice to be here.
Just give us a brief rundown of what Resolve Legal Group does and your roles with the company.
Well, I can tell you that I am the founder of Resolve Legal Group and a senior family lawyer. We take a kind of different approach to family law in the sense that we know that family law is not just about a legal matter. In fact, any personal area of law is not just about the legal matter because you're dealing with families as a whole. And we know that until you can kind of deal with some of the family dynamics, you're not going to be in the right headspace to deal with the legal matter. So what we try to do is we try to make sure that families get the support that they need while going through these processes so that they can more effectively make decisions about their family from a headspace rather than from a visceral space. And this mostly pertains to family law. So while we have families that are emotionally charged and feeling a certain way about the separation of the family, we really need them to be ready to deal with the legal matters. And to best address that, we have a role at our firm of the client support coordinator who takes the family and helps get them whatever supports they need or whatever help they need from a non-legal perspective so that the lawyers can focus on the legal stuff with their clients. And the client support coordinator can make sure that our clients are feeling supported in all other areas. So client support coordinator's role is to help with getting counseling set up and not just, giving out leaflets, but we know that when people tell their story over and over and over, that can re-traumatize them. So our client support coordinator actually signs a confidentiality agreement with the client, and they're the person that tells their story over and over and over to the ancillary services that we bring on to assist on a file, whether that be a financial expert or a counselor, or the client support coordinator could even just be there to help families, find new daycares if they're moving to a new area. Because when you're going through separation or divorce, it's like walking through mud, and everything that you do feels like a lot of work, even just making a phone call or even just finding out about those daycares or getting information. So we've kind of had our client support coordinator be that person that assists with making those calls and assists with getting the client in a better place so that they don't feel like they're walking through mud. They feel like they've got somebody there making a path for them to make it easier to deal with some of the more visceral and emotionally charged things that they need to deal with respect to their separation.
Would it be safe to say that you offer sort of a holistic approach, and this is my way of introducing you, Dr. Thiessen?
Yes, I would say that Resolve does provide a holistic approach. There's a strong emphasis at Resolve on the client and making sure that our services are client-focused. We have one of the few services offered that I'm aware of, which is a client services coordinator, so somebody in the firm who's dedicated to being there to help answer and bridge support between client and legal people. I'm one of the few people in the firm that is not really from a legal background, although I suppose technically I am. I work as a family mediator, but my background academically, scholarly, is in Islamic law.
The website, again, is resolvelegalgroup.com. There is a 1-800 number you can call, 1-866-RESOLVE. And now let's dive into it because we got a lot to discuss when it comes to family law. There's a lot of changes that we're going to discuss, changes to the Divorce Act, retroactive support, Clare's Law. But let's begin with the Family Law Property Act. There's a change in that. It's a new name from what I understand, Cindy.
Well, it's a bit more than a new name. It's a pretty significant change. There hasn't been a lot of changes to family law over the years since I've been practicing. However, in the last couple of years, we've seen a lot of shift go on, and some might say for the better. The first real shift happened with respect to matrimonial property. So prior to January of 2020, the landscape looked like this. We didn't have any legislation that would help people who were in what is commonly referred to as a common law relationship divide their property. So they were at the mercy of going to the court and making what was called an unjust enrichment claim if they had one. And from there, lawyers would hash it out in front of a judge or even in negotiations. But we were at the mercy of whatever the case law said about the property with unmarried people. Married people, however, we did have legislation, and it was the Matrimonial Property Act. And how it worked was there was a presumption of 50-50 division of property, and we kind of did an analysis starting from there, some properties exempt, et cetera, et cetera. But for the most part, regardless of which party's name the property was in, if you were married, there was going to be that presumption that everything would be shared 50-50. That was not the case for unmarried people. When the Matrimonial Property Act was replaced with the Family Property Act, all of that changed. So now, after January of 2020, if you're in a adult interdependent relationship or what is commonly known as common law, your property is going to get divided very similar to the way it would had you been married. So there's no real distinction there between unmarried people and married couples as it had been in the past. Now, I will say Alberta is one of the only jurisdictions that actually doesn't recognize common law couples. So when you hear the word common law, it's kind of a misnomer, if you will, for Albertans, because here, even though from a tax perspective, you could be known as a common law couple, in Alberta, that wasn't recognized. But the main takeaway is that before, unmarried couples and married couples were treated very differently when it came to property division, but now they're treated very much the same.
So how long do you have to be in a relationship before it's considered a common law relationship?
Well, again, in Alberta, we don't recognize common law relationships. That's not recognized in this jurisdiction. So instead of being common law, you essentially have to meet the criteria under the Adult Interdependent Relationships Act, or you have to have what's known as an adult interdependent partner, the acronym being an APE. So you have to be an APE, essentially. And what that means is you don't have to be hairy and living in a jungle, but you do have to either have a contract that says that you are adult interdependent partners or APEs, or you have to be living together and have a child together or adopt a child together. And the third way that you can be defined as an APE or adult interdependent partner is if you have been living together for 3 years. And all of that is defined under that piece of legislation, the Adult Interdependent Relationships Act. And then you take those definitions and you start your analysis from there as to whether or not you're in that kind of relationship. And if you meet that criteria, then your property is divided in accordance with the new Family Property Act. And it's the same whether you're married or unmarried and in a relationship. Whereas before, the significant difference was married people and unmarried couples were treated very, very differently, and now they're essentially treated the same under that new legislation that we now have in Alberta, which makes property division a lot easier. However, there is some people who don't like it because one of the reasons why they chose not to get married was so that their property would be treated differently. So for those couples now, they have to kind of address that by entering into a cohabitation agreement or a prenuptial agreement.
And I suppose when it comes to divorce or splitting up, it can get a little emotional at times, and that's where a family mediator really comes to help, right?
Well, it's not just the emotion. Sometimes there can just be a very different sense between the two parties of what property belongs to which one or who should get it, whether they're emotional about it or not. Mm-hmm. And a family mediator is going to be there to try and help the couples work through what the real issues are, like get down to some of the interests and move people away from positions so that we can really understand what is it that they want to go away from this with in their hands, and also at the same time help them avoid the acrimony that will come out if they're pursuing litigation in the courts.
So that's the nuts and bolts of the Family Law Property Act, formerly known as the Matrimonial Property Act. We are talking with Cindy Morin, senior family lawyer with Resolve Legal Group, and also Dr. Wesley Thiessen, family mediator with Resolve Legal Group. If you want more information, you can go on their website, resolvelegalgroup.com. The 1-800 number, 1-866 Resolve. We have lots to get to when it comes to family law, talking with Cindy and Dr. Wesley Thiessen. Topics such as changes to the Divorce Act, Clare's Law, retroactive support, mediation, and some of the in-house programs offered by Resolve Group. So don't go anywhere. Talk to the Experts continues with all of that next on 770 CHQR. This is Talk to the Experts on 770 CHQR. I'm Randy Sharman. Joining me today is Cindy Morin. She's a senior family lawyer with Resolve Legal Group, and Dr. Wesley Thiessen, family mediator with Resolve Legal Group. The website is resolvelegalgroup.com, and there's a 1-800 number you can call if you have questions and want to find out more, 1-866-RESOLVE. Very easy. To kick things off, we mentioned the Family Law Property Act. Let's talk about child support now and some of the changes that are going on there.
Sure. So we know that with child support in 1997, there was the first really big change that hadn't happened to family law in a long time, and that was we came out with federal child support guidelines. So prior to that, how we determined how much child support should be paid was kind of, again, just relying on the case law, and it was a hit and miss kind of thing. So in 1997, the federal child support guidelines came into play, which are law, and it says, depending on where the payer parent lives and the recipient payer lives, there is a slight adjustment as to what you would pay, but there's an obligation for the payor to make sure that they are updating their child support every year based on whatever their income is. This is necessary because if they don't update that information annually, and if their income changes, they could be on the hook for retroactive child support if there was an increase in their income and they didn't make those changes. That then triggers the payee parent to go and bring an application, or could potentially bring an application, not only to readjust ongoing child support payments, but also retroactive. But in a Supreme Court of Canada decision that came out in December of 2020 called Michel versus Graydon, in that case, the court looked at going back beyond 3 years for retroactive support, so long as there's a really good reason for the delay in bringing an application. Oftentimes I get the question, well, can we just make an agreement that nobody pays support? And the answer to that is no. Child support is the right of the child. It can't be contracted out of. So it's really important that payors take responsibility themselves. Don't wait for the payee to come forward and say, hey, I want more, or I want to see your financials. Just exchange those financials on an annual basis and make the adjustment themselves so that they don't end up with a big bill for retroactive support. And quite frankly, this is your children, so you should be supporting them and wanting to support them. I will say this, however, if you get a really good child support order, you can, and it's worded properly and drafted properly, you can use services like the Maintenance Enforcement Program to collect child support, so that, and payers like this too, because it takes away the whole fight about, oh, I didn't get my support, or I did, and it just takes that away from a conflict situation where you have a third party being kind of like the collection person, so that when you're co-parenting with your former spouse, you can really kind of focus on the kids and not the money portion. I always tell my clients, look, let's get you a really good, solid, well-drafted child support order that's enforceable. Let's get that into place. And then what we do at our firm is we set clients up so that they don't have to keep coming back to lawyers on an annual basis.
Let's talk a little bit now about the Divorce Act itself.
Sure. So there's three grounds for divorce. One is you're living separate and apart for a year, and living separate and apart can also mean living in the same home. It's just that you, in your mind, have decided and announced that you're done. So that's living separate and apart for a year. That's one ground for divorce. The other one is adultery. And the third ground for divorce is physical or mental cruelty. The difficulty is, what is mental cruelty? I mean, it's easy enough to identify physical cruelty because there's bruising or injury associated with that. So from an evidentiary perspective, that's easy to prove. But mental cruelty is something that is kind of subjective on one level, but we do know that there is a certain pervasive level of it that would meet the test for mental cruelty, but it just wasn't defined. So in the Divorce Act, they're now shifting, and they've changed the legislation a little bit. And what I want to focus on in this segment, while there's been many changes under the Divorce Act, the one that I feel personally for my practice is the most important is the changes around coercive control. So when I think of mental cruelty, I think of being controlled in a way where I don't feel like I have freedom of choice as a person. And that's my own personal definition of that. So with the changes under the Divorce Act around coercive control, the courts now look at patterns of pervasive behavior where somebody's been controlled by, having their money limited, because we do know that there's many different forms of domestic abuse. And one of them would be, financial abuse, emotional abuse, verbal abuse, all of that. So again, verbal abuse, you can kind of say, well, you can give examples of what's been said to you and how you've been treated. But these things were not really addressed that much prior to the changes under the Divorce Act. So when we're talking about things like domestic violence or intimate partner violence or domestic abuse and domestic assault, all of these, interchanged kind of terms, what we're looking at is trying to prevent family violence in the first place, and that was kind of one of the goals with the changes under the new Divorce Act. And coercive control, when you're dealing with family violence, is more prevalent than physical violence or any of the other areas of abuse, and it encompasses many areas of abuse. A lot of that is enveloped by coercive control. So these changes are significant in the fact that we've never looked at those things before under the law, and they've been needed for a very long time, and now we're going to be able to address them because we have that avenue, that legal avenue to do that now.
So how do you prevent a he said, she said scenario when it comes to, mental abuse, that type of thing that is a gray area and not as cut and dry to prove?
So I think the best way to answer that is it really starts with the lawyer that you have. You need to choose a lawyer that is motivated on helping your family restructure in a healthy way and not one that's just going to fight every little thing, because it is easy for families, even the most amicable families can still get caught up in conflict because you're dealing with highly emotionally charged areas of law. Mm-hmm. So it really starts with the lawyer, in my opinion, to be kind of the person to say, look, we don't want to be mudslinging, but we do need to bring certain evidence before the court in order to make a case. And you've got your version and they've got their version, but it's always good to have corroborating evidence to support your position, and more so from an independent third party like a psychological assessment or somebody who is a bystander that's witnessed something that doesn't know your family, as opposed to family and friends, because of course, you get those alignments during a separation or divorce, and that can become problematic. My job as a lawyer is to say, look, we don't want to attack the other side. We want to just bring the facts to the court, protect you, and do what we need to do to make this a restructuring process in the healthiest way possible with the least amount of conflict. But you also don't want to go to somebody who just says mediation, 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 because while mediation is very effective and I'm very pro-mediation, sometimes if you have a certain kind of high conflict situation, you don't necessarily want to go to mediation, because I always say you can't reason with the unreasonable. you also want to make sure that whatever lawyer you're using or whatever mediator you're using really understands high conflict matters in family law, because they're very different from other kinds of typical family law files. And so you need somebody that's got that background and experience to work with those families in order for any one of those processes to be effective.
And I guess, Dr. Thiessen, when you talk about mediation, that's where you come in.
That's right, and I would agree with everything that Cindy has said. One of the first things that we do as mediators is certainly my practice. It's not the case of every mediator. So just like you have to be careful about the lawyer that you choose, you also need to understand some things about your mediator. Mediation is a profession in Alberta that's not actually regulated. And so anybody can hang up a shingle that says that they're a mediator, but you want to find out who the person is that's actually going to be taking care of your very personal and intimate and conflictual matters. And the first thing that I would do is I would interview each of my clients and assess whether or not they're appropriate for mediation, because some cases I will just say, we can't resolve this in a good way for you through the process of mediation. Now, that being said, I am still, of course, very pro-mediation, and I think it's an option that everybody should consider when they find themselves in a situation where they want to separate or divorce, and especially if they have children, because the court process is something that's actually going to be very detrimental on the children, and it's really the last place that you want to have your family matters resolved. You don't want a third-party judge who's just looking at the evidence that somebody's brought in over the last couple of hours to make the decisions that are going to impact your family for years to come.
We are talking with Dr. Wesley Thiessen, family mediator, and Cindy Morin, senior family lawyer, on Talk to the Experts there from the Resolve Legal Group. The website is resolvelegalgroup.com. If you have questions, certainly give them a call, 1-866-RESOLVE. We've got more to discuss. Clare's Law, another new law in Alberta here that we'll discuss when Talk to the Experts continues on 770 CHQR. Welcome back to Talk to the Experts on 770 CHQR. I'm Randy Sharman. Today we're chatting about family law with Cindy Morin. She is a senior family lawyer, and Wesley Thiessen, who is a family mediator. Both are with Resolve Legal Group. You can check their website, resolvelegalgroup.com, or call them up with your questions at 1-866-RESOLVE. And we were talking a bit about some of the changes to the Divorce Act, and part of that had to do with the issue of family violence and spousal abuse. And recently, the Alberta government announced a new law surrounding that known as Clare's Law. Cindy, what is Clare's Law?
Again, this is a new law that came into effect this year on April 1st, and really made some significant changes around family violence prevention. Now, I have the good fortune of having my junior associate, Eric Law, here with me listening in, and I'm going to actually have him talk about it because he's been doing the most work around it at our firm in helping our clients.
I think an overview of the law is probably the most prudent here. In Alberta, it's called the Disclosure to Protect Against Domestic Violence Act. Clare's Law, it's called Clare's Law because it comes from the UK. It was named after a victim of domestic violence who, if she had known what the police had known, may still be alive today. And what Clare's Law in Alberta does is it allows any Albertan to know if your current or past intimate partner has a history of domestic violence, stalking or harassment, breaches of no contact orders, or other relevant acts. The most important thing about this is that your partner will not be notified, or your former partner will not be notified that you have requested this information. And this information can come to you one of two ways, under two rights. Albertans have the right to know. So police, if they have a concern about your partner, can proactively inform you about your partner's history. You also have the right to ask. You can do this by filling out a request form, which you can find at alberta.ca/Clare's Law. That's CLARESLAW. Now, if you're exercising your right to ask, there are privacy concerns built into the law. So you should know that if you make an application and there is relevant information to disclose, you can only review the information in the presence of a police officer. You cannot record this information in any way. You cannot take notes or pictures. You will not get copies, and you cannot use this information in any court proceedings. The point is not to be able to use it. The point is to be able to know so that you can make an informed decision about your safety. However, what we also need to remember is that this is not some proverbial silver bullet. It cannot eradicate domestic violence in this province, and a person may be years into their relationship before they even have an inkling that their partner has the capacity for violence. And such, this tool must be used in conjunction with the plethora of other supports that are out there for people who experience domestic violence. So one of those supports out there in Alberta, they're called Suggest. It's suggest.org. They're a great place to start if you are a victim of domestic violence or are concerned about it. They have a live chat function that can help you get the supports you need.
Randy, if I can also just add to that, Suggest is also a really good organization that helps our clients develop safety plans when they're wanting to leave a particular relationship where there has been intimate partner violence or any kind of family violence of any kind. And we actually work very closely. Our client support coordinator does. This is another example of what the client support coordinator at the firm can do. If we screen for the domestic violence and we determine that there has been some, whether it's our client that is the offender or the victim, we reach out to Suggest because both parties need support and both parties need help because, it's not just the victims that have the issue, but also the person who is the abuser also needs some support to learn how to manage their own behaviors and their own and take responsibility for their own behaviors in the relationship. So Suggest is a really good organization. They're open to anybody to get some support from them, as well as the Calgary Counseling Centre. We've been partnered with them ever since we opened our doors 10 years ago, in making sure that people get those supports that they need to better work with the family and help the family to overcome these issues because they're very pervasive, and it's a huge problem in Alberta. So this is one way that our firm and these community supports can help people get safety plans in place and work with the family better than what a court system would do. And I do know that Andrea Silverstone, who is the executive director of Suggest and is completely amazing with the work that she does with these families, when I asked her if there was anything that she thought people should know about Clare's Law, she texted me and said that it's important for everybody to understand that there has to be a relationship in order to ask for this information, and all of the guidelines are in the application online. And that if you're making an application in the first place, it means you probably need some social support. So again, if you're not already connected to different social supports, there are social supports available to people across the province, and you can access these by checking off a box on the application requesting for those social supports, which is huge. Finally, for third-party applicants, like a friend or a family member making an application, it's hard being an informal supporter and worrying about someone that you care about in an abusive relationship. So for those third-party family members who are saying, what do I do to help, say, my daughter leave this relationship, or my son get some help because his wife is controlling the money, or whatever it is, Suggest is an organization that can also help those family members help the family that they're involved with from that third-party perspective. And that's, again, even for any offenders. If they're saying, I recognize I have a problem and I need some help, our client support coordinator and our lawyer, Eric, who is focusing on that area in his practice right now, they're really good resources to help any member of the family.
So when you're talking about your role in assisting in all of this is part of Resolve Legal Group's support system, and it's all done in-house, right?
Yeah. So again, talking about our client support, our client support coordinator really has three roles. So she's the person that you would first encounter at the firm. She does all of our intakes. And one of her roles is she matches clients with the right lawyer for their matter. And that's important because we know that we're dealing with very personal areas of law, very personal matters. We want to make sure that our clients have a good fit with somebody that they feel like they can connect with and work with, because they're going to be working with this professional for a big chunk of time, and that professional is going to know a lot about their life, and we want to make sure that there's a good fit personality-wise as well as content-wise. So we don't want to give, say, somebody who has a high conflict matter to the guy that dabbles in family law but focuses on real estate, right? We want them to be with the right fit. So that's her first role. Her second role is to be that liaison for the client, as we mentioned, where she goes out and gets the different supports that our clients may need and request, so that they don't have to do that legwork and they can just focus on their legal matter. And then her third role in the firm is she will follow up with clients from time to time to make sure that, they're happy with the services and that things are going the way they expect it to be going. And we do have, when we do initial intakes, we do have a very transparent list of what people can expect from us when they come to the firm. And if anybody's dropping the ball in any one of those areas, then they can also call our client support coordinator anonymously and say, hey, I was told that my call would be returned within 48 business hours, and nobody's returned my call, and this happens all the time. We don't use it as a way to penalize our lawyers, but we always want our lawyers to be the sharpest in town and the best in town. So if they're falling short on any one of those promises that we give to our clients, we use it as a means to coach those lawyers and make sure that we are also giving them the assistance that they might need to be able to achieve the level of care that we promise to our clients. And because we know that not everybody feels comfortable calling in, or they think, she might tell somebody and they're worried about somebody spitting in their soup, we make sure that she does like regular callbacks and check-ins with the clients to make sure that, they're getting the support that they need, whether it be from the legal end or even just the community support end.
Okay, I'm going to pause you there. We've digested a lot here, so we'll take a break. And when we come back, we're going to learn more about Resolve Legal Group's in-house programs, including Help with Kids in Mind. We're talking today with Cindy Morin, Senior Family Lawyer with Resolve Legal Group, and Dr. Wesley Thiessen, Family Mediator, also with Resolve Legal Group. The website is resolvelegalgroup.com, or simply call them 1-866-RESOLVE. This is Talk to the Experts on 770 CHQR. You're listening to Talk to the Experts on 770 CHQR. I'm Randy Sharman. Today we're learning a bit about family law with Resolve Legal Group. We've been chatting with Cindy Morin, Senior Family Lawyer, and Dr. Wesley Thiessen, Family Mediator, both with Resolve Legal Group. Their website is resolvelegalgroup.com, and the phone number is 1-866-RESOLVE. Cindy, we left off talking about the client support offered with Resolve Legal Group. Is there a separate charge for this, or how does it work?
It's a free service. So the client support services are free, and then that way the client doesn't have to worry about, being overbilled for things like needing to find a daycare, which isn't really a legal question, but often a question that I used to get as a lawyer, should I buy a car? Should I lease a car? What daycare should I send my kids to? Like all of these questions that aren't legal questions, they used to come to me as the lawyer. And of course it's my time that is being taken up, and there's a charge to that time. So now I can say, you know what, let me get Deanna, our client support coordinator, to assist you with that so that there's no charge to you. And once you've got that settled and you can focus on the legal stuff, come back and let's work on the legal stuff together. So it's a really good marriage, and I know that our firm is the only firm that's offering that service right now in family law. There's a couple of personal injury firms that offer the service, but we're the only family one in Alberta that I'm aware of, and it's something that I really, really encourage other firms to do because it was one of the best things that we ever implemented in the firm. Another program that we implemented in the firm that is helpful is we know that legal matters don't just happen between 9 and 5 during business hours. So we actually have lawyers on call and we do a rotation so that we are there 24/7. Because if there's a dispute going on and it's 6 o'clock at night on a Friday, you're not going to be able to get in and talk to your lawyer about it till Monday. Typically, we want to make sure that we're there, and in particular around the holidays where high conflict situations arise. So for our clients, we offer that 24-hour availability of a lawyer to assist whenever they need it. And then we did a study with the Calgary Counseling Centre about 4 years ago on a program that we developed. So let me back up here and tell you that every single client, and I mean every single client I've ever met with, always asks the question, how much is this going to cost and how long is it going to take? Well, we don't know, because we don't know what the other side's going to do, how they're going to respond, if they're going to drive matters to court, if they're going to cooperate and do an alternative dispute resolution process. We just don't know. But after doing this study, we were trying to come up with a way to deal with custody matters in particular, which are always the most expensive and always the highest charged cases. How can we come up with a structure that we would be able to best assist these families in a way that we can say, yes, this is how much it's going to cost and this is how long it's going to take. And with that, I will let Wes tell you more about Kids in Mind, because he's really the backbone of the program.
Well, the interesting thing about Kids in Mind is when people come up this question of how much it's going to cost and how long it's going to take, the program has been developed so that it's actually a flat fee service. We resolve those problems for our clients from the get-go and say, this is the service that we will provide and this is the price that you will pay for those services. That being said, you will receive the impartial professional work of 3 individuals, not only the mediator, but also a psychologist and the family lawyer. And these people will be working with you through the entire part of your process. This is a 4-stage process. We begin with the initial assessment, and then there's a psychological educational component. This talks about toxic stress as well as the Alberta wellness research on brain development to try and help determine what are the best resources that are going to help this particular family. So the assessment is made and then resources are recommended. Right at the beginning, we would do an interim mediation with the clients. And this is to ensure that we're going to deal with urgent issues right away. If you go to court, sometimes the process can take a very long time. And all of the time between the decision that you've made that you're going to go down the divorce path, and then when you finally get the judgment that comes out from the courts, people are basically in limbo. But in our program, with an interim mediation, we will make some decisions about what's going to happen right away with the family and the children. So we take care of that limbo scenario. And then we work on making sure that the family at that point gets the parenting plans in place. They start to receive some of the services that they need. They start to find some balance in their new life. And then we work on a longer-term mediation with long-term goals. When that is all complete, we've come to an agreement with each other. 6 months later, we'll follow up with the families to make sure that things are working well for the family. One of the components that we've also added, because sometimes people aren't so keen on mediation, is to give them a little bit of motivation. We introduce a component of arbitration. So there's sort of a deadline. You need to complete your mediation within this time frame. And if things get really protracted and it's obvious that they're not going to be able to come to a solution themselves, then the matter can shift over into arbitration, where the mediator takes off the mediation hat and puts on an arbitration hat and works with the clients to make a judgment to come to a conclusion so that their matter can be resolved in a reasonable period of time.
So I think the important takeaway with this as well is we know that in high conflict matters, there's usually some underlying issues going on with the family, whether it be drug or alcohol addiction, family violence, sometimes mental health issues. And the nice thing about Kids in Mind is we have the psychologist there who specializes in child psychology in particular, who can help identify what the underlying issues are. And then we can send the family out after we've got like a very interim plan in place that we can take the consultation from the psychologist working with our families and send the families out to do whatever work they need to do to kind of address some of those underlying issues so that they can better deal with the legal issues when we come back to deal with child custody on a more permanent basis at phase 3 of the program. The other thing I wanted to mention too was when Wes was talking about the psychoeducational component, the Alberta Wellness Initiative is an organization that did a whole bunch of research on children's brain development. And what we know from that research is that when children are exposed to high conflict for long periods of time, otherwise known as toxic stress, it can actually change the brain chemistry of the children. And this can perpetuate ongoing problems, for generations. So it's really kind of a community health issue if you look at it from that perspective. It's important that we work with these families. We triage them in such a way that we get them the help that they need early on, which a court process can't do. Our job as lawyers should be to work ourselves out of a job, in my opinion. The lawyer's footprint on a family should be minimized as much as possible. And the best way to do that is to educate families and give them the tools that they need to work together better on a go forward in a healthy way for the benefit of the children, which benefits the community as a whole. These are very pervasive issues that have ripple effects that need to be nipped in the bud. And Kids in Mind is just one example of a program that can nip things in the bud quickly and cost effectively.
Cindy Morin is a senior family lawyer with Resolve Legal Group, and Dr. Wesley Thiessen is family mediator. Resolve Legal Group is the company. ResolveLegalGroup.com is the website. If you have questions, the number to call, 1-866-RESOLVE. And you've been listening to Talk to the Experts on 770 CHQR.